Court is calling 2022 CR 7806, State of Texas versus Johnny Tahada. Can I have parties announced for the record for the state?
Jason Jorgens for the state.
Defense.
Alex Shar for Mr. Tahada.
And are you Mr. Tahada?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tahada, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor. We're waiving count 2 and proceeding on count 1.
Any
No
objection?
No objection.
Mr. Tahada, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count 1, you're charged with the offense of failure to stop and render aid resulting in death? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today? I'm sorry. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
And did you understand in regards to your plea bargain agreement, the court does not have to follow that agreement?
Yes, Your Honor.
And if I don't follow that agreement and give you more than you bargained for, you can withdraw your plea. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe that. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both.
Mr. Tahada, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count 1, waiving count 2. Punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. No application for deferred adjudication. State recommends community supervision. They will take in consideration 2022 CR 7807, 2022 CR 7808. There's to be restitution payable to the next akin for Dylan Trevino, Melissa Aroja, Arauja, and then payable to victims under 2020 CR 7807, Mario Huarte, Yuarte, and 2022 CR 7808, Monica Bell. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes, Your Honor.
Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
We haven't had any hearings on any motions.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation, 200 hours of community service restitution, the MRT, and regular UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense is charged in count 1. How do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor. The state offers Exhibit 1, the defendant's waivers and stipulation of evidence, as well as the discovered knowledge for this case.
No objection.
Mr. Tahada, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all of the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. And state, have you had an opportunity to receive a date?
Your Honor, our next of kin indicated that she could come in on any day, so sometime later this week should be fine, or at the court's convenience.
Okay. Does she want to come in tomorrow or Thursday or Friday?
Just give her some time. If we could do Thursday or Friday, Judge, just to make sure she can. Oh, or not.
I can't do Friday. I have a
Okay.
federal sentencing in Del Rio in the morning.
So then Thursday, Judge, if the court's okay.
Is Thursday okay with you?
I'll have to check my schedule, but I think it is. I will do that before I leave,
Okay. Oh, well, you want to check it now?
just to be sure.
Oh, yeah, sure. Go ahead and check it.
All right.
And thank you, Judge. We appreciate the court's
Oh.
accommodation for that.
Oh, no problem. And Caroline, before you go, could I see the file on Mr. Scott, or have you already taken that back? Thank you.
Set in Kendall for an arraignment in the morning. You may be able to waive that arraignment. I could be available in the afternoon.
All right. How far is Kendall from here?
It's not too far from me because I live out that way. It's about, but getting out of that court is, half a morning type thing.
Okay. Do you want to set it for Thursday in the afternoon?
That would be great.
All right, State, are you okay with Thursday? And let's say Thursday at 1:30?
As far as I know, Judge.
All right, so Norma, on Mr. Tahada, we'll come back for sentencing on the 9th at 1:30. All right, is there anything else from either side?
No,
No,
for
Your
sake.
Honor.
All right, if you'll get the reset form from Ms. Ferguson, then you're excused.
Thank you.
Thank you, Your Honor.
You're welcome. 23 CR 0791 State versus Ronnie Simons Jr. Can I have parties announced?
Rick Fania for the state of Texas.
John Robertson from the Diamonds.
All right, you, Mr. Simons. All right, so defense, your client had all previously pled true to violations 2, 2, 4, and 4. The court found 2, 2, 4, and 4 true. The state's recommendation and probation's recommendation is for inpatient treatment.
Yes.
Probation in the state is asking for safety, you're asking for SATA. The reason why, and they tell me, as a judge, you should never let people into your brain to see your thought processes. But I don't pay attention to that because I think people need to know that I've heard what parties have said, right? So the reason why I wanted to know about his employment, because honestly, I don't know if he should be in SATF or SafeP. Maybe this is a situation, I don't want him to lose his employment. Maybe this is a situation where I send him off into the world. And if he tests positive, I know the motion to revoke is going to be filed. Do you understand? Probation, do we have an updated tap on Mr. Simons?
I want to say you did, but
Well, if I may, Your Honor.
Yes.
Court summary says the last tap was completed a week ago
Ah,
while he was in jail, and they recommended ISF2 followed by aftercare with the ISP unit. But despite that, probation's recommendation was still SafeP followed by SafeP aftercare.
all right. So here's my question. Has he ever had intensive outpatient treatment or no?
He has not, Your Honor, however, it was never made part of his terms, no.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you speak up so that I can hear and the court reporter can hear. Can you state your name for the record?
Ronnie Simons Jr.
All right, this is what I'm going to tell you. You know yourself. If you're honest with yourself and really look in the mirror, not looking at what you want, right? But what is best for you. You know yourself better than the state, better than your attorney, better than probation. Now, what I'm being told by your counsel, and he's the officer of the court, he called. It appears that you have been employed. I don't know if at your employment they do drug testing or not, but it appears that you were working. And maybe you were afraid, which I don't understand why people are afraid of me. Just come in and tell me, and I'm going to make a decision based upon what I hear. So you know yourself best. So you have to ask yourself, one, can I survive in this world, not violating my conditions of using if I am given intensive outpatient treatment? Thank you. That's my question for you. Are you able to do it? I know when people are released from the jail, they're just so happy they're not going to prison. They're like, I'm going to follow through on everything that's given to me. I'm not going to mess up. I'm not going to use. And then 2 weeks later, they're back to using. So that's my question to you. Positive what?
Yeah, I'm gonna say I'm not gonna use.
All right. So your employment, what exactly do you do?
I get sent to different apartment complexes and start the grounds mornings to do work orders, make readies on apartments.
Well, no, I mean, are you working outside in the heat? All right.
Basically, that's it, just on site wherever it is, and so if I get a permanent job, if somebody wants to hire on, they'll go through the staffing with the process.
All right. Probation. How much is the patch?
The drug patch is $50 every 2 weeks.
All right. There's nothing I can do about that. So here are your two choices. And state if you're in disagreement with the choices I'm going to give them, please let me know. And if you're in disagreement, let me know. Probation, you're in disagreement, let me know. The patch is $50 every 2 weeks. What the patch is, it's a patch. They put it on you. You are not allowed to remove it. It shouldn't come off if you're showered. Now, there have been some people who worked in constructions, and there have been some issues with the patch because of the temperature here in San Antonio and the humidity. That's why I was asking you if you work outside. You can either do the patch and it will be for 90 days, or either you can do the UA hotline for 90 days. And with the UA hotline, they're going to call you. You're going to get tested. You're never going to know when you're going to get tested. And if you test positive, then I'm going to follow the recommendations that probation is set forth for the court. And that will be inpatient treatment, maybe with SAP, or it may be revocation, prison. It just really depends. So thoughts?
As long as probation is fine with that, I'm fine.
Because my main thing is I don't want him to lose his employment if he's finally, I know it's hard for people to get employment when they are felons or not felons, even when they're on deferred adjudication.
Well,
Yes.
my concern though is regarding the two number 4 violations. He's living with the people that are on the no contact order.
Oh, well, that's going to change. You can't live with them. And we can put him on GPS.
I would ask for GPS, yes, until indefinite, until your honor says
So
differently.
here are your choices. Number one, you cannot live with people on the no contact order. Not allowed. That's what the no contact order is for. If they want the no contact order lifted, they need to come in and have a conversation with me, because I need to make sure that people feel safe. And the state needs to make sure that people feel safe, because if something happens, they're going to ask me why I lifted a no contact order. You understand? So you're not allowed to be with them. So you can either do one or two things. One, I'm going to place you on GPS. It'll be GPS. We're going to start with GPS partial for employment. And then once he's proven he's able to do certain things, then ultimately it'll be tracking. Then ultimately it will be removal. But you're not allowed to reside at that household or have contact with the people who are on the non-contact list. Do you understand? Or if you want, you won't have to do the patch. You won't have to do the UA hotline. You go into custody and you wait for transfer to SATF. And is it the patch or the UA hotline? All right. So probation, this is what the court is going to do. Court will deny the motion. Alter and amend to include the patch for 90 days. Partial GPS for employment only. That will be for 90 days. Then after that 90 days, if there are no issues, we'll look at tracking only, and then ultimately removal. And there's to be intensive outpatient treatment with probation. And you need to provide probation with your residence address within, how long is it going to take? Do you have some place that you can stay? I'm sorry, what?
I let my apartment go, so.
So who are you going to be living with?
To cost.
But you do have family members or somebody who will let you stay with them?
Yes, ma'am.
All right, probation. He's going to provide you with his residence address within 72 hours of release. All right. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, if you don't remember your conditions, you need to speak to your probation officer and have them go over those conditions again. If you violate this probation, what's going to end up happening is a motion to revoke is going to be filed. you'll be taken into custody. Either you'll make bond or you won't make bond. Either you'll be continued or you'll be revoked if probation is able to prove up those conditions. And with your case, you're looking at potentially up to 10 years in the prison. Do you understand? All right, good luck to you.
Can a hit-and-run driver escape maximum punishment with a cheap plea deal? Judge Boyd just proved that the answer is a definitive no. The final conclusion in the state of Texas versus Johnny Tahada is here. Facing charges for a fatal hit-and-run, the defendant pleaded no contest in hopes of securing a recommended 10-year sentence. But here is the real twist. Judge Boyd made it crystal clear that she is not bound by this agreement. She warned him that she has the full authority to reject the deal and hand down the absolute maximum sentence. The legal conclusion? The court officially found Johnny Tahada guilty, and he has officially waived all his rights to appeal. But instead of rushing to judgment, Judge Boyd completely halted the sentencing. The final sentencing is now rescheduled for Thursday at 1:30 p.m. to ensure the victims' families are heard. The message is clear. When you leave the scene, you leave your freedom behind.